A man walks into court trying to pay a fine and walks out on probation instead, because he missed one court date and his diversion deal evaporated. Jamarian Thomas thought he was settling a simple marijuana possession case in Kansas. But when you sign a diversion agreement, you're signing away more rights than most people realize.
5. The order does not appear to address setting the matter for trial and stipulated facts, but that would be the state's understanding of how this matter should proceed pursuant to the terms of the diversion agreement.
Okay, so the state has made a motion to revoke diversion. Did Mr. Thomas fail to appear on December 1st?
That would be the state's information, Your Honor.
Okay, but if he had appeared, that would have been the posture of the case, trial and stipulated facts.
Your Honor, at the December 1st hearing, it would appear that the court did hear the, well, forgive me, Your Honor, that would appear accurate given that the order revoking diversion had been previously granted a hearing back in April of 2025.
Okay, so the diversion has been revoked. We still need to do the trial and stipulated facts.
That would be the state's understanding, Your Honor.
Okay, Mr. McGear, I don't have a copy of the diversion. Could you read into the record what the stipulated facts are?
One moment, Your Honor.
Your Honor, may I ask again what case we're on?
Yes, it is. I'm sorry, I didn't say the number. I apologize. It's Jamarian Thomas 2023 CR 300046.
Thank you. I am also showing this is set for a motion for judgment on bond.
Okay.
And Your Honor, the pursuant to page 3 of the diversion agreement, the stipulation facts includes 2 counts, possession of marijuana, a class B non-person misdemeanor, possession of paraphernalia for use, specifically a paper bag, class B non-person misdemeanor, both those occurring in Butler County, Kansas on the 24th day of November, 2023.
Okay. So, Mr. Thomas, do you understand that Judge Webster revoked your diversion, and contained within that diversion were some stipulated facts that the court would look at if you did not successfully complete your diversion?
Yeah.
Okay. Well, I am going to find you guilty pursuant to the factual basis just given to me by Mr. Regier, the stipulated facts. And Mr. Regier, what could you tell me again, if you haven't already, what was in the diversion agreement as far as sentencing?
Yes, Your Honor, one moment. Yes, Your Honor. Pursuant to page 2 of the diversion agreement, it appears to refer to a $200 fine for count 1 and no fine for count 2. State would make both those recommendations, as well as the imposition of court costs, which do appear to be $158, also on page 2. Insofar as the issue of KBI restitution, the diversion.
A trial on stipulated facts isn't really a trial at all. It's a sentencing hearing disguised as one. When Thomas signed his diversion agreement, he pre-negotiated the facts the court would use against him if he failed. No witnesses, no cross-examination, no jury. The Sixth Amendment guarantees your right to counsel at all critical stages, which is why judges must confirm you understand what you're giving up before accepting any waiver.
The diversion agreement appears to be silent on page 2 of that issue, so the state does not make any recommendations on that front. The state would recommend a concurrent 120-day sentence for both counts, as both those appear to be charged as Class B misdemeanors. The state would also recommend 6 months reporting probation, all standard conditions, that the defendant be ordered to complete a drug and alcohol evaluation and follow recommendations if the court deems appropriate. The state has no objection to the defendant receiving credit for any payments already made towards the balance of the case, excluding the diversion agreement. And additionally, later on in the diversion agreement, it would appear to indicate under the waiver of rights section, give me Your Honor.
Yep.
Specifically, under item 2, that the defendant waived his right to a speedy trial, and under item 10, that the defendant waived his right to counsel. If the court finds that the prior waiver of counsel is continuing this matter, the state would request leave to journalize that in the journal entry from today's hearing.
Mr. Regier, can you say again what count one was and what count two was?
Yes, Your Honor. The stipulation of facts appears to refer to count one, possession of marijuana, a Class B non-person misdemeanor for count one. But count two, possession of paraphernalia for use, a Class B non-person misdemeanor for count two.
All right. Mr. Thomas, is there anything you would like to say?
My bondsman made me turn myself in the other day, and I went to McPherson or whatever, and they told me I didn't have a warrant or anything, so they just let me go. And
Okay. Do you understand that when you signed this diversion agreement, you stipulated a factual basis within the diversion agreement and waived your right to a trial? Do you understand that?
yeah,
Okay. All right. I'm going to find you guilty of count one, possession of marijuana, count two, possession of paraphernalia. It sounds like you had some agreements in the diversion agreement about sentencing should you be revoked, which your diversion has been revoked. Is there anything you would like to say in regards to sentence?
so when I missed court December 1st, and that was I had contacted Christina Bastion, which would be my diversion officer. And that was because on 11/29, my car, that's November 29th, I blew my engine coming back from Salina heading to Wichita, so I didn't have any transportation. I don't know anyone in Wichita, so like it's just me here. I like do everything here, so I couldn't contact anyone.
Okay. Okay, thank you for that information. As far as the sentence, where Mr. Regier is recommending a 200, well, and I think the diversion agreement also, there was an agreement for a $200 fine on count one, court cost of $158, 12-month underlying jail sentence and a 6-month reporting probation.
And forgive me, Your Honor, the state had recommended for an underlying sentence of 120 days for both counts concurrent. The state has not recommended a 12-month underlying sentence, as both these appear to be charged as Class B misdemeanors.
I am so sorry. I read my notes wrong. Yes, 120-day underlying jail sentence with a 6-month reporting probation. And part of that probation, you would have to get a drug and alcohol evaluation. Do you have anything you want to say about that piece of it?
No.
No. Okay. And we'll take up the bond issue in a minute, but I am going to follow the diversion agreement and what Mr. Regier presented to the court. So 120-day jail sentence on each count concurrent, but that is an underlying sentence, so you will not have to serve any, at least not right now. 6-month reporting probation. One of the conditions of probation is you will have to get a drug and alcohol evaluation, Mr. Thomas, and follow those recommendations. There will be a $200 fine on count one. There will be $158 in court costs. Mr. Regier, did I miss anything on the sentencing?
Your Honor, if that reporting probation is to be subject to all standard conditions, the state would also be recommending the standard supervision fee, which the state understands to be $60 in this matter.
Okay. Yes, yes, Mr. Thomas will be subject to all standard conditions of probation. I'm not going to impose any KBI fees, but there will be the probation supervision fee of $60. Did I cover everything now, Mr. Regier?
That would appear accurate from the state's understanding, Your Honor.
Okay. All right. Let's switch gears to the matter of judgment on bond. Mr. Regier, since Mr. Thomas presented himself to court this morning, we did the trial and stipulated facts. He's been found guilty, been put on probation. Are you still seeking the judgment on bond, or are you going to withdraw that, or what?
Your Honor, given the proceedings that have occurred here today, the state would move to withdraw the motion for judgment on bond. The state's information is further that the defendant had previously executed an appearance bond. Forgive me, I'm locating that. Yes, Your Honor. For an appearance back in September of 2025, that was the first appearance before Chief Judge Rickey, and the matter was reset over to the December 1st date, at which time the defendant failed to appear. Following the failure to appear, the court did enter certain orders in accordance with that, and the state will defer to the court as to how we should proceed in light of the orders from today.
Okay. Well, I'm not gonna order any judgment on bond. I think we took care of Matt. Mr. Thomas presented himself to the court. He took care of business. So I think let's just leave it at that.
Very good. Your Honor.
Will Mr. Thomas need to report to court services right after court today?
If the court given that the court has ordered a reporting probation, that would appear to be appropriate.
Okay, Mr. Thomas, you understand that?
Yeah.
Yeah, just head right to court services as soon as we're done here, okay?
Okay.
All right. Anything further?
Can you guys make sure you have my updated address? I don't get any mail for anything, so
Sure, go ahead and give us your
it's gonna be 605 South Patty.
PATTIE or something else?
PATTIE.
And Your Honor, the state would respectfully suggest that any additional information the defendant may or may not choose to provide would best be provided to the court services officer.
Okay, yeah, I think that's a good idea. Provide it to the court service when you go down the hallway. Okay?
All
All
right.
right.
Thank you.
Okay, we are in adjournment. Mr. Thomas, head over to court services now. Okay.
It's just gonna be down.
Okay.
And I have Miss Wickham coming in. That'll be the last one we have here.
Miss Wickham. Okay, let me find those notes. All right, and your Tally Wickham, is that right?
Yes, ma'am.
All right, let's go on the record in the case of State of Kansas versus Tally Wickham, 2025 CR 259. Could party state appearances, please?
Jeremy here on behalf of the state.
Okay, and Miss Wickham, are you appearing without counsel today?
That is correct.
Okay. Mr. Regier, could you advise me of the status of this case?
Yes, Your Honor. This is a case that first came before first appearance before District Judge Satterfield back in September of 2025. The information in this matter alleges an occurrence date of almost a year prior on count 1, April 30th, 2025. It alleges one count of purchase or consumption.
Judge Webster found Jamarian Thomas guilty of both misdemeanor counts based on the stipulated facts in his revoked diversion agreement. He received a 120-day underlying jail sentence, suspended, 6 months of reporting probation with standard conditions, a drug and alcohol evaluation requirement, $200 in fines, $158 in court costs, and a $60 probation supervision fee. The state withdrew its motion for judgment on bond, and Thomas was ordered to report immediately to court services. Diversion agreements are contracts with the state. Break any term, even by missing one court date, and the entire deal collapses. The trial that follows is often just a formality because you've already agreed to the facts and waived your rights. Read every word before you sign. The consequences are preloaded and waiting. Subscribe for more real courtroom moments that show you how the system actually works.